most common governance for a partnership is the partnership agreement, which is typically drafted by attorneys. It should be anyway, because there are some generalized language in there that you could use from partnership to partnership, but they do have to be customized and tailored to the wants and goals of the partners that are starting up the partnership. So that's the first place to look. And then you may have also two different statutes that will govern the partnership. Most of the time, those are in place if the partnership either doesn't have a written agreement, which is not wise, or if there is some type of conflict between what are in the state statutes and what are the terms that would be in a partnership agreement. So typically, the things that come up within the partnership agreement that govern the partnership have to do with certain responsibilities that partners have to other partners and to the entity as a whole. So you have to make sure that that there is language in there that protects, in the partnership agreement, that protects the partnership entity from self-dealing, whether that is in regard to some kind of breach of fiduciary duty. So you can't put your own personal financial well-being ahead of the partnership's well-being. You owe a duty of care to the other partners, and that means you can't, even if it's not intentional, you can't act with negligence or reckless disregard for the well-being of the partnership, even if you're not doing that for your own self-interest. So basically, you just have to make sure that that those types of terms that are relative to the type of business that the partnership is going to be engaged in addresses fiduciary duties to the other partners, duties of care, duties of loyalty and good faith. Some of those overlap, some don't, but typically the whole idea is that the partnerships are working within whatever legal means they have to make the partnership work and to make sound business decisions. Doesn't mean you're going to be perfect, but it does mean that you can't act with negligence or reckless disregard. You can't put your self-interest above the interest of the partnership when those may in fact conflict. And then that's something else that should be in the partnership agreement, is that even though that's also a statutory regulation, is that you have to disclose anything that might lead another partner to believe that there would be some kind of conflict or self-interest between that partner's personal gain and the partnership as a whole, the well-being of the partnership as a whole. So those things should be in the partnership agreement, which is the main document that would govern the partnership. Whenever there's litigation involved, the first thing you look to, and the first thing that a judge or jury is going to look at, are the terms of the partnership agreement and whether or not some type of conduct, either through an active some type of overt act, or if it's just some type of omission, that a party has acted or a partner has acted without the best interest of the partnership in mind.